So, good afternoon, everybody. Thank you very much for joining this webinar today. It's a pleasure to have you all as part of it. The webinar is being recorded, so we will, of course, make sure there is a recording available to you as soon as that becomes ready, and we will make sure that that is distributed as well. For anyone who doesn't know me, I am Jo Dickens. I head up business development at the Barbour Insurance Group. We trade as the brands HomeLet and Let Alliance. And I'm joined today by my colleague, Will.
Hi everyone, so I'm Will Eastman and I am the Director for Legal for Lettings, which is a law firm within the group.
Thanks, Will. What we'd really like to talk to you about today is just some of the experiences that we have come across and some top tips that we have put together around helping you protect your reputation and helping you around some of the situations you may encounter with problem tenants. I think it's fair to say that we all know that one bad rental can really tarnish your reputation. And when things do get tricky, it can be very, very tough to obviously manage your landlord, customer, and your tenant client. We're all aware that fraud is on the rise. We're all aware that criminal activity is on the increase. And given the coming of the Renters' Rights Bill, the fact that we know that we've potentially got landlords who are exiting the market, we've got increased rents, we've got a decreasing supply of stock, it's obviously imperative to make sure we're trying to work together to source the best tenants and to help you in a situation where things do go wrong. So we're going to talk a little bit today around some real life examples, situations that we've actually seen within our legal team where things have gone wrong, and we've obviously worked with the agents to navigate those tricky situations. Some strategies to try and avoid rental problems before they arise, some things to look out for. And some tips on handling tenant disputes, late payments, and property damage. And then we're going to talk a little bit about the court process and some of the challenges we've got there as well. So I'm just going to hand over to Will, and what Will's going to do is he's just going to talk us through a few live examples, some case studies. We have these, by the way, in an anonymised format. If you think they would be helpful in any of your marketing literature or to share with landlords or anything like that, as I say, they can be completely anonymised. So I'll hand over to you, Will, so that you can just give us a flavour for some of the situations that we see in legal.
Thanks, Jo, and I'll try and keep it relatively high level, so I'm not talking at you for minutes and minutes, but there's three cases that I really want to go through, I think, that highlight some of the challenges that you will have as agents, landlords, with tenants when you have a problem tenancy. And I think it's worth saying that, you know, working with your tenants and maintaining a good relationship sort of is the umbrella laying over all of the things that we do in legal. So I'll start off with case study one. So this was a property let out to a couple who then moved their daughter in, and one of the tenants was quite vulnerable. So it started off as a straightforward possession claim, Section 8, Section 21. But at the hearing, there was issues of disrepair, harassment, and some issues around the service of prescribed documents raised. So the court then adjourned proceedings to obviously deal with that and give the tenants the opportunity to file a proper defence, fully pleaded, and they went off to instruct Shelter to support them with that. It became quite difficult because they were vulnerable. So there was an issue of mental capacity, and so court deadlines were missed by the tenants, but that resulted in his having to jump through a few hoops to get a litigation friend appointed on behalf of the vulnerable tenants because they lacked mental capacity. So first of all, we needed to apply for a mental capacity assessment. Then we needed to deal with the court and getting a litigation friend appointed, which was actually the official solicitor who was appointed. And then the matter can proceed and set down to trial. So I think it goes to show that what can start off as a straightforward claim can quickly result in a lot of complex applications having to be made to make sure that the court is satisfied that both parties get access to a fair trial and to legal representation. So that's case study 1. Case study 2 is more around people acting on their own rather than having legal representation, which can be tricky in itself. Again, what seemed to be a straightforward rent arrears claim. Just before the hearing, the tenants have applied to adjourn the hearing, as often tenants do. I mean, the reason was to attend a sports event, so they couldn't attend the hearing. They were generally very difficult individuals to deal with, refused to give any evidence or refused to provide us with any documentation towards their defence or counterclaim that they said they had. Just before the hearing, they raised issues of disrepair with the council. So the council were then involved and the local environmental health officer was involved. Their defence was a breach of quiet enjoyment and disrepair. And you'll probably see disrepair is a very common defence to possession proceedings. The reason we've sort of talked about a far-fetched defence is one element of their defence was the landlord. It was quite a rural property, and the landlord was allegedly running an illegal abattoir at the property. So when they did attend the hearing, so they obviously didn't go to the sports event, they attended the hearing. They turned up with a Ziploc bag of bones to prove that an abattoir was being run on neighbouring properties, which is quite unusual to deal with at the door of the court. And the court naturally adjourned the proceedings and gave them time to file the appropriate defence and paperwork. There was a lot of to and fro in this case, backwards and forwards with the tenant who just simply refused to deal with the court directions, mainly because they were unrepresented and misunderstood what was needed of them. But we eventually got to a hearing. We eventually got the defence and counterclaim dismissed and got possession on that case. But again, it goes to show that anything can happen once you've started the process. And case study 3 is more about highlighting landlords who don't have the benefit of an insurance policy. So we've acted for a landlord recently and the letting agent who don't have any rent protection, rental cover, and are instructing us privately on a fee-paying basis. And this was a Section 21 accelerated claim. It was issued in July 2023, so I think that probably gives you an indication of where we're going, but defended in August 2023. The court then made mistakes in striking out the claim in August 2023 without any hearing, so that was having to reapply to the court to reinstate proceedings, and we did that in September 2023. It was defended, and so the court gave directions to both parties to tell them what they needed to do in November 2023. But the hearing they set down, and I dare add, this is a central London court, they set the hearing down for September 2024, so nearly a year later because of the court backlogs. And at the hearing, the court has then set the matter to trial to deal with the elements of the defence. But because of the court backlogs, that trial has been set down for October 2025. So obviously this poor landlord with a tenant not paying rent, and a defence which, you might say is meritless, but the court want to hear it and want to have a trial on the facts, will wait 2 years from when it started as an accelerated through to when they may well get a possession order. But of course, even when they've got a possession order, you then have to wait for the bailiffs, which in London is still a number of weeks. I think we're looking at about 17 weeks at the moment. So,
and I guess, Will, at the moment it's completely out of our hands, as providers in the marketplace, as letting agents, as landlords. Once we do need to go to court for eviction of a tenant, we are completely in the hands of the court and their backlogs.
Absolutely. I mean, we can chase the court, we can call them, we can do as much as we can to sort of move them on, but the sad reality is the court system is inundated in possession claims. They haven't got the infrastructure to deal with it, and especially central London. I mean, this court was Willesden, but the courts around London and Greater London are really struggling to cope with volumes.
And I don't think a lot of our clients as landlords are really aware of the huge challenge that they could face if things you know, if things do go wrong and they find themselves in one of these situations like the case studies that you've just alluded to. So I guess that quite nicely brings us on to how we can work together to look at strategies to potentially avoid problems before tenancies commence. And as you can imagine, in the business that we're in, we do tend to see a lot of tenancies when things have gone wrong. You know, we see claims coming into our team. We see landlords contacting the legal team, Will's team, because they have reached a situation where they do need to evict the tenant. That can be because of rent arrears, that can be because they want the property back, or obviously it can be for things that are perhaps criminal activity, subletting cannabis farms and things like that. So as and when we get those scenarios, what we try to do is look at how could things potentially have been done better up front. It goes without saying, you know I'm talking to a room full of letting agents here, but we've got to try our best to educate landlords that they need to use professional letting agents. You know, they're really up against it with legislation now. I see a lot of our letting agent partners who will do landlord webinars, who will release material to landlords, very much talking about how the landlord should protect their risks when they're renting out their property, and what could potentially happen if things do go wrong. It goes without saying, you know, we would always encourage people to use a reputable tenant assessment company, look at data, look at technology, try to obtain an actual factual assessment on the individual that you're looking to move in. It's incredible the amount of tenants we catch through behind the scenes checks. So looking at our default tenant database, for example, you know, any of our clients, whenever we reference a new prospective tenant for a property, we will always check and see whether we've had a historic rent guarantee or possession claim against that individual and what the reasons behind that were. If we have individuals who we've become made aware of who have sublet the property, who have acted outside of their tenancy obligations, we also keep a log of those. We keep our own logs of suspicious applications and data, and we also directly deal with CIFAS, which is the National Fraud Database. So we're always checking all of those things. You as agents will probably want to do additional checks, things like social media checks. You know, a lot of the time you are in a relatively local area, a lot of your tenants will be in the local area, and that local knowledge is of paramount importance. So I know a lot of our customers will also resort to, as I said, the likes of social media to do some checks on there as well. If you're doing your own checks up front, always be careful that you've actually verified the source of any references that you've taken. People who we find set out to defraud are people who can actually buy things like fake bank statements and pay slips online. This is really, really easy to do now, and it's, you know, it's not an awful lot of money. And to the untrained eye, you know, these documents can appear legitimate. Very, very much the same with ID that you're collecting. Try and use some kind of government approved, either IDVT type software, which can allow you to virtually verify the ID in the presence of the holder through a video call like this. So the applicant will be prompted to do what they call a selfie and liveness check, where they'll rock their head round. I don't know if anyone's ever been through an application for some of the like the modern banks like Revolut and Monzo and things like that. They quite often use that type of check to digitally identify someone. But obviously, if you're doing it in a traditional way, seeing that true original ID in the presence of the holder, and obviously making sure, you know, to the best of your ability that that is a genuine document. All those sorts of things are going to help you with making sure that you are dealing with the people that you believe yourselves to be dealing with. Goes without saying to be meeting individuals in person. We have had scenarios where a guarantor has never actually met the letting agency, has sadly not even had a conversation with the letting agency, and it transpires further down the line that the individual that has been listed by the agency as the guarantor has actually never given consent to be the guarantor, which can obviously present a challenge. So make sure those guarantors are consenting and are, you know, known to you to be willing to be the guarantor. We're in a bit of a cashless society, I know, these days, but we would also say steer clear of cash, credit cards in offices, even debit cards. So I know in my days of agency, many years ago, we would always say, please pay by bank transfer. We don't take cash and we don't take credit cards, but we did used to take debit cards. I don't know if you're aware, but credit and debit cards these days are covered by the chargeback guarantee. And in a lot of fraud cases that we do see, what we will find is that a tenant has been able to move into a property. Someone has perhaps not followed the correct process in branch, has allowed the move in to go ahead with payment on a credit or debit card, and that money is subsequently clawed back by the bank, leaving you in a situation where you have a tenant living in the property who has not paid their first month's rent, has not paid their security deposit, and is now not paying the ongoing rent because they've managed to move into the property fraudulently. So we would say always insist on something that's very secure, like a direct bank payment to your bank account that appears in cleared funds before the keys are handed over. Another thing that is quite common that we see, especially where we've got situations that the properties get turned into cannabis factories, are things like people asking about bills being included, people being very aware when they're going and doing the viewing about the accessibility of the property, potentially about whether the property is overlooked. Another interesting one is the proximity to things like electrical power lines, because as we know, a lot of the time what they will try and do is bypass the supply meters and go directly to the power line. So these are just some of the things to be looking out for before a rental commences. And then during the tenancy, again, some triggers that we see, because not only do we get made aware of cases when they do go wrong from the point of view of rent arrears or the illegal activity, we also see this on the other side of things where the tenants have finally gone and the landlord's in a position where there's been malicious damage at the property and they are therefore looking to claim on their buildings and contents insurance. And again, you know, cannabis factories are something that, you know, will typically take tens of thousands of pounds to put right. So tenants obviously refusing access for inspections. Common themes with them are that they won't allow access, they'll change the lock straight away. They might even suggest to you that they've lost their keys. They'll then attend the office to borrow your management set of keys. You never see those keys again, and subsequently the locks get changed. Building materials appearing around the house and blacked out windows. These are other common signs to look out for, along with excessive heat, lots of comings and goings, extractor fans, pungent smells. They're all signs of cannabis farming. It's not just about cannabis farming. Obviously, there's also people out there who will take on properties because they want to use them for other illegal activities. You know, we see brothels, we see people taking them on and trying to sublet them. You know, properties being marketed on things like booking.com and Gumtree, again, because of the shortage in the market. We've had cases whereby somebody's taken on a 3 or 4 bedroom detached house as a single person, and then actually has been renting the rooms out individually. So those are all the sorts of things to look out for. And, you know, when you're doing your midterm inspections, make sure that you're looking out for the conduct within the property. You know, how is it being used? We had a case not so very long ago, again, a large detached property that had been rented to a single individual, and they had people staying in each of the rooms and sleeping bags. There was an overcrowding problem, and they were probably going to be profiting from that property illegally as well. We would always encourage you as a business to make sure you've got appropriate liability insurance in place if the worst does happen. You know, things like your PI, make sure that that is there and in place to cover you should the worst happen. And without scaring them too much, you know, and then maintaining an element of calm, I think it's important that landlords do become aware of what could go wrong in a tenancy. You know, even the best tenant who has checked out and who is not fraudulent can fall on hard times. They can have a change in circumstances. And I think it's important that landlords are aware of that. You know, we've already heard from Will up front, one of those case studies, you know, 2 years to get a tenant out and you're completely in the hands of the courts. I don't think landlords have a real awareness of that. And I think it's for us, you know, as a combined to try to educate them around that. It's also important that the landlord has appropriate protection in place. You know, has the landlord got buildings and contents insurance that could cover them in the event that a property is damaged maliciously? Has the landlord got appropriate protection in place that will allow them to meet their mortgage and meet their mandatory repairing obligations and pay for repairs and maintenance that are required if the worst does happen and the tenant doesn't pay the rent for whatever reason? And neighbour feedback, you know, speak to neighbours if you've got concerns, you know, if you see some of the telltale signs, if you have been struggling to get into the property, you know, it's always worth a knock on the door to the neighbours just to see whether there's anything that they can make you aware of. And, you know, get to it early. If there are concerns, if there are things that you feel you need to do a little bit more digging into, do so. It's another thing that's very common that we see, that news articles and things will be released further down the line when someone might have already moved into the property. You know, sadly, we as a referencing business and you as a as letting agents, we're not able to access the Criminal Records Bureau, but we can access BBC News and things like that. So it's always worth looking out for any future breaking articles if you have concerns over individuals in properties. And then obviously it's about the right support to then be able to get those people out and get your landlord their property back. So when it comes to disputes, late payment, property damage, you know, I've talked a lot about the fraud aspect and things like that and the criminal activity, but obviously it's also really important to make sure that should a tenant default on the rent, that we are trying to help them wherever possible. If COVID taught us anything, it was that actually a lot of landlords were willing to do things like rent deferrals. They were willing to negotiate with tenants. We all know we've got renters' rights coming, and it's going to be more important than ever to try and maintain good, healthy relationships with tenants. You know, it can save so much in the long run. So as soon as you become aware of a tenant's inability to pay the rent, try to contact them, try to get to the bottom of the issues that they're causing, because tenants will bury their heads in the sand. And as soon as they get to the point where they've missed a whole month's rent because they've spent the money or they never had the money in the first place, trying to then work their way out of that black hole is really difficult. So we would always encourage you to try and work with the tenants wherever possible. I mentioned inspections before, you know, whether you do it yourselves, whether you outsource it, whether you do drive-bys, you know, try and do regular inspections, take photos wherever it's appropriate to do so. Also look at your credit control procedures. A lot of the CRMs that are out there now, they can help you to automate that credit control process. They can automatically send things like emails, text messages, even WhatsApp messages if you've got those types of integrations. You know, softly, you haven't paid your rent. It's now 7 days late. Is there a problem with your bank? please talk to us. Obviously making contact as well early on with guarantors, if you have a guarantor on the tenancy agreement. All these are the sorts of things that can help. Of course, if you do end up in a situation where your tenant's going to bury their head in the sand, what we need to do is make sure that we're putting you in the best possible position should we need to go to court. So make sure your CRM's giving you accurate rent schedules and effective rent chasing letters. Build your evidence. Keep really clear and detailed notes. Keep really clear, detailed information on maintenance logs and things like that, because you will need those at the point at which we go to court. You know, we all know there are programs out there like, you know, rogue tenant, slum landlord. You know, I don't need to tell you guys how difficult it can be to get possession, and you know, judges are always looking to err on the side of the tenant. So making sure that we've got absolutely everything in place at the point we get to court is really, really important. So if you do get to the point where you're looking to recover possession of the property, then obviously that's where, of course, we can support you. But what we'd always say is prevention's better than cure. Get the experts in as early as possible. Don't be alone. You know, we all know legislation is changing at a rate of knots. Judges will throw things out on minor technicalities. Get ahead of the game. Before you serve a notice, you know, check, have you complied with the prerequisites of that notice? Have you served all the mandatory documents? You know, have you served your prescribed information? Have you served your deposit T's and C's, your EICR, your EPC, your gas safety certificate, your how to rent guide? Make sure, belt and braces, it's all been done before that notice is served. And once the notice is expired, check that the tenant is still in the property, even if you hadn't had the keys back. Like, we know that generally, excuse me, you'll serve the notice, the tenant won't go, you'll need to then start the court process, but still check, because there are situations that we come across where actually the tenant has gone, it's very clear they've gone, you could avoid a lengthy battle going to court with them. Avoid unregulated specialists who are around. Make sure you work with a regulated law firm. It will be very easy to check that they're a regulated law firm because they'll be regulated by the SRA, which is the Solicitors Regulation Authority. And if tenants don't leave on expired court orders and things, instruct bailiffs quickly. You know, there's massive delays in the county court. You know, again, case study 3 highlights that, and I'm sure, you know, there will be people on this webinar who are going through this process as we speak. So it's hugely frustrating for landlords, but obviously the sooner you can get your instruction in, the better. So we're just going to hand over to Will to talk a little bit about maintenance issues, because this is one of the things that becomes a challenge really, really often when, of course, a tenant's fallen into arrears. They then realise things are getting a bit serious here because someone else has got involved. There's a legal firm after me, and inevitably start throwing things out there, which may or may not be true. And we see that quite a lot in legal, don't we, Will?
Yeah, we do. So you will have seen from the earlier case studies that on each of the defences raised, it's generally disrepair, amongst other things sometimes, but disrepair is the issue. Now, of course, every tenancy, every house is going to have at some point some maintenance issue that needs to be resolved. The key thing is respond within a reasonable time. And what is reasonable really depends on what the issue is. You know, if they haven't got any central heating or the boiler's not working and it's the middle of winter, then reasonable is very quickly. If it's the middle of summer, you might take a bit longer. Just make sure it's in a reasonable time, and it's just to respond to them in a reasonable time and tell them what you're going to do. You don't have to fix it straight away, but fix it obviously as fast as you can. Keep a clear record of everything that you do, whether it's a contractor visiting, if they can't get access, the attempts made, and keep a record of any email attempts to the tenant to book appointments or telephone calls. It's also really important to retain the invoices or the job sheets confirming that the work's been done, because whilst the tenant will raise that all of these issues are outstanding, they often deny when the work's done. So it's important that you've got the evidence there to show that the issue was raised, you responded promptly, you resolved it in a reasonable time, and here's the evidence to show it's resolved. And I know it's not always possible. Sometimes contractors work completely electronically, but if they have got job sheets or they're able to electronically sign, getting some sort of signature from the tenant at the point that the work is complete, or emailing them afterwards to get them to confirm back in a reply that the work is complete and the issue is resolved, will be really helpful when you get to court, if you get to court, and if they defend it for maintenance issues, because it can show the court that they've accepted it's resolved. There is no defence to the proceedings. We see a lot of cases now where the tenants will go to the local authority in the hope that they can help, and especially with the proposed renters' rights bill and the increased focus on how they're going to ring fence funding for local authorities to enforce standards, housing standards, make sure you engage cooperatively with environmental health officers or local authority. And if they are involved, or you do get served with an improvement notice or a relevant notice about improving the conditions of the property, then get legal advice. So you know what your rights are and what your obligations are, just to make sure that you dot all the I's, cross all the T's.
Thanks, Will. So it goes without saying that, you know, reputation is everything to everyone, and what we would try and help you with today is just some of the sort of tips around being able to have good upfront processes and things like that to be able to protect yourselves as letting agent businesses. Because of course, if everything goes wrong for a landlord, even though you as the agent won't have done anything wrong, it will still be that, you know, you guys will become the bad guys. So I think being able to demonstrate and evidence that you've done all you can to support your landlord is really, really important. And, you know, we've also had scenarios where we've seen that perhaps things have gone wrong for a landlord. A letting agent has then made an introduction for that landlord to a legal partner. The legal partner's been able to get that tenant out. That landlord then is much more aware of the risks that they face, and actually goes back to that letting agency and wants to take on a tenant with additional protections and things like that in place. So how would I sort of summarize? You know, I think good upfront processes and good sort of pre-vetting and referencing, look at adequate protection to protect both your business and your landlord's asset. Have a real awareness of fraudulent activity in the market. I have got so many anonymized screenshots and things that I can share that show where documents have been adapted and things like that we've flagged on AI technology. As I said up front, you know, we've got case study examples of where things have gone wrong. So if they would be helpful, please don't hesitate to reach out. And if things do go wrong, you know, be able to evidence you've done all you can to protect your landlord, and get the experts involved as early as you possibly can. We're all about helping you generate revenue, but we're also about how we can protect you and your landlord clients. So I'd like to say thank you again for everyone who has joined today. We hope that, you know, this has been informative and helpful. You will see that on the pack, both myself and Will's direct details are there. So do feel free to reach out to us directly if you've got any further sort of questions or bespoke scenarios that you would like to chat through or anything like that.